Rolling.
Thank you. Let's go on the record. Good morning. I'm board member Stacy Moniz, and I'll be presiding over today's proceeding. Also present are board chair Marcus Oshiro and board member Cesnita Moipono. Today is January 25th, 2024. The time is approximately 9:05 a.m. We are here today regarding case numbers 23 CE 05976, 23 CU 05400, 23 CE 05978, and 23 CU 05398. In the matter of Donna Campbell, David Reid, and Cecilia Best, complainants, the respondents are the Department of Education, State of Hawaii, and the Hawaii State Teachers Association. This is the fourth day of the hearing on the merits. Would each party or their representatives please enter their appearances for the record?
Good morning, my name is David Reid. I'm representing Campbell and Cecily Best.
Good morning, Mr. Reid. Good morning, Ms. Campbell and Ms. Best. Mr. Takei? Good morning, Mr. Takei. Mr. Lapa?
Morning, Kiani Alapa from Response HSTA.
Good morning, Mr. Alapa. Good morning, Ms. Eshelman. Yesterday when we left off, Mr. Takei, I forgot to ask you if you had any other witnesses. Recognizing your request for Mr. Bacon, is there anyone else?
Thank you, board member. At this time, DOE would like to move the board for leave to add one witness and 3 documents with the board's approval. I hope for an opportunity to give an explanation.
Please. Mr. Reid, you got to respond after he gives his explanation.
DOE in its pretrial statement reserve the right to supplement its witness list and exhibits list as necessary. DOE would like to add 3 documents to its document list. One document is DOE's policy regarding DOE's periodic repricing review. And 2 documents are past memos sent to the superintendent regarding the completion and results of the periodic repricing review. DOE would like to add a witness to his witness list. Her name is Andy Yamagata. She works under Mr. Bacon at the Office of Talent and Management. She can authenticate the documents and provide testimony as to the existence of a written policy and explain the policy. These documents and witness were not included earlier because it was not foreseen before this hearing that issues regarding a written document about repricing review would arise. 89.9F2 does not have a requirement for any written documents. While Mr. Bacon testified as to DOE's established procedures to periodically review repricing, he said he couldn't recall whether there was a written document about repricing review, but Mr. Bacon never denied the existence of a written policy. The witness and documents will not contradict Mr. Bacon's testimony, but will only supplement it. Introducing Ms. Yamagata and the documents is relevant and probative as to whether a written document exists. It's my job to make sure to provide all the relevant facts to the fact finder so the board can make an informed decision at the end without making wrong assumptions based on incomplete information. These reasons outweigh any undue prejudice arguments that complainants may make. Complainants have an opportunity to cross the witness and review the document. I have nothing further.
Okay, thank you, Mr. Takei. Mr. Alapa?
I have no objection to the report.
Thank you. Mr. Reid?
The claim that this is unforeseen is not credible. This has been in the pleadings months. I even expressly explained this at the end of our last hearing when we asked for clarification, and I literally stated the exact case I laid out. I said there were no procedures, there was no action review. I said this in pleadings. I said this directly to his request for clarification. Directly, it is not unforeseen. It should have been the most expected part of my case in chief. This highly prejudicial last second appearance of evidence is highly prejudicial to this proceeding. Finding things overnight, and it is his job to follow the procedures and to be a competent lawyer and to follow the deadlines, meet the expectations, of this board. And there was ample time to research this. There was a similar case in April of 23. Same issues were present. This is not a surprise. It's not unforeseen. The deadlines were clear. The expectations were clear. There needs to be a high standard for meeting the expectations. I have done my very best to meet them with literally no training. And I strongly oppose any introduction of new evidence outside of the rules, outside of the board orders, especially the extremely prejudicial documents that they were bringing.
Thank you. Mr. Takea, since it's your motion. The
Yes,
last day.
if I may respond.
Sure.
Mr. Reid, I believe pleadings that he is referring to, the DOE submits that he did say that there was no procedures pursuant to F2, but it was never specified that he was making an allegation that there was no written procedures. And you know, the statute clearly doesn't require, or at least not explicitly, any written documents regarding periodic review of pricing. As to the case that Mr. Reid is referring to that took place earlier last year, which my assumption is he's talking about Jennifer Kramer's case. In that case, 89.3 was not not one of her claims. I believe, and this is just off my knowledge at this moment, her claim was based on the 13A8, which is violation of the CBA. And so at this hearing, Mr. Reid is alleging 89.3 violation, and in his earlier testimony, he said his employee rights were violated because DOE did not follow F2 correctly. So the claims in the Jennifer Kramer case is not the same as this case. And today I'm not saying that the witness and the documents won't be prejudicial. In fact, it probably will go against you know, his arguments. But my argument or reason for asking for this motion for leave is because the witness and the documents are the probative value and the relevancy outweighs any prejudice to the complainants. Thank you.
Mr. Reid.
Our recollection of the testimony is Mr. Bacon said no documents existed. Established procedures within the Department of Education, 6.5-year employee. Are written down. That is a professional expectation for the state of Hawaii. If I were complaining against a mom and pop coffee shop, that might be different. Their established procedures might be oral. But this is the state of Hawaii Department of Education with their established procedures. As an employee, I tell you, there's no lack of paper, toner, staples, or folders to which to contain these procedures. He mentioned that 89.3 was not alleged in Ms. Kramer's case. The documents they're suggesting have nothing to do with 89.3. That is apples and oranges. Her case, the position of the Department of Education was it was illegal repricing under 89.9 F2. That is the same claim they're making now. These documents are about whether it was a legal or allegedly they're pertaining to the possibility that it was a legal 89.9 F2 that was found literally overnight. Literally found miraculously overnight. That was that was an unequal comparison. He is confusing the issues between 89.3 and 89.9 F2. And I'm just, yeah.
Thank you, Mr. Reid. Mr. Alapa?
Board member, we just want to address the appropriate value argument. And although the union's case has not been presented, I am relying on the testimony that was provided for its case. And as I stated yesterday, I took issue with some of the statements made by Mr. Bacon, but he did testify that during the consultation process for repricing, he worked as a team. There were multiple members of that team. And I can, and I anticipate that our testimony will be that representations were made to the union. There were written policies and procedures in place, and we relied on that information. So I am interested in hearing from another witness who may be a part of the team who assume that's the case. Because I want to call that witness also as a rebuttal witness based on the testimony that's provided to the employer. I think it makes sense to have that witness come now, so I don't have to do it myself, and I can ask my own question at that time. I think there is probative value not only for the employer's case, but also for the union's case, which I intend to address, and I think it just makes sense to address it here and now.
Yeah, I understand your position, Mr. Alapa. Let me just clarify. Yeah, because yesterday you made a request to possibly call Mr. Bacon as a rebuttal witness, and I think my ruling was to the effect that we would cross that bridge when we get to it. Would you be withdrawing that request or recall Mr. Bacon in light of this proposed new witness?
Yes, I would, and listening to your comments yesterday in response to employer's request, I think it made a lot of sense, and I think what we intended to do is set a foundation on the other team members from the employer. Use one of those witnesses as a request for a rebuttal. But at the end of the day, the answer is yes, I will withdraw my request for rebuttal. Assuming that the purpose of the testimony is related to the team that the employer had participated in a consultation with the.
Okay, thank you.
One.
Mr. Reid.
I just want to state that if the employer had the resources to find this evidence at the last second, they had the resources to find this evidence in October and professionally meet the deadlines. They had the resources to professionally do this anytime before and meet the deadlines of the board. Based on my prior readings of decisions and how cases have gone, deadlines are enforced to the day. Evidence has been excluded because things have been excluded because they were late, because they didn't follow procedure. And the idea that the state of Hawaii could not find some papers that they were well aware of that they needed until the very last minute, after all the professional deadlines are gone and the expectations of the legal system, and it's highly, I haven't seen them, but I'm going to assume they're highly prejudicial because they determined what their deficiencies were through the course of my case in chief. And we should have done. I don't know, but I would assume the deadlines and the procedures and the professionalism is meant. It doesn't allow that.
Okay, thank you. The board is going to take a recess, subject to the call of the chair. Thank you. Back on the record. Mr. Takeda, the board has confirmed and discussed your motion. And frankly, it's very similar to what you tried yesterday with Mr. Bacon. You're just substituting a different name as a witness to try and come in and produce these documents. And I have to state again, and I'm not saying this in a way that's critical or negative, but the claim that the DOE was not aware of the requirements of F2 being central issues to this case, frankly, rings hollow with the board. In fact, you've spent a great amount of time going through the various statutes with this. We have problems with, is it Miss Yamagata?
Yes, it's been told to me, her name is Sandy Yamagata.
Right, okay. To the best of the board's recollection, Miss Yamagata's name, setting aside a witness list, doesn't appear in any document that's been produced in this case, to the best of our knowledge at this point. So no party would have any type of notice of Miss Yamagata's involvement in this. I know you mentioned that she could authenticate the documents. If that's the case, then she should have been named as a witness. Because I will tell you that the board's recollection is that Mr. Bacon's testimony wasn't just he couldn't recall, that there were no procedures. So in reality, when you tell me you're going to call a witness, like a rebuttal witness, you're actually rebutting your own witness. You're actually impeaching your own witness. And to that extent, as I said with Mr. Bacon, and I do want to add that these so-called documents would have been in the exclusive possession of the department, meaning the three complainants don't have access to it. And according to Mr. Alapa's representation, the HSTA didn't have access to it. So it's solely within the exclusive possession of the DOE. The board is finding that there is no surprise here to warrant this additional witness because of things that have unfolded here in the case. And frankly, it's an attempt to rehabilitate your own witness that you called, who was the lead person by his own testimony in these negotiations. So the board is going to deny your request. Mr. Alapa, again, the same thing. We will deal with your request when we get to that.
Thank you.
But as far as your request, Mr. Takeda, that is going to be denied. The prejudice outweighs the value and the basis for adding this witness and these documents. Being surprised, and you can correct me if I'm wrong, that you didn't know that these issues were central to the case. Based upon that, it's going to be denied. And I'll let you respond if you want.
Okay, well, I understand that the board has already made their decision. I just want to state that it appears that the board's decision is in part at least, based on the board's recollection that Mr. Bacon affirmatively denied that there was any written policy. I without seeing the video again, it is my understanding that he represented that he did not remember whether there was a written policy or not. And so assuming that he did say that there was no written policy, I can understand the board's explanation just now that it appears that I'm impeaching my own witness and using this witness as a rebuttal witness. But if Mr. Bacon actually did say he didn't remember, then this witness would not be a rebuttal witness. She's just supplementing his witness and is not contradicting anything that he said. At least my understanding is Mr. Bacon didn't know, and he went back and at least through the testimony of this witness that was denied, we wanted to show that there actually was, and it just refreshed Mr. Bacon's memory that there was one, and we could clarify whether or not there actually was one or there wasn't one. Thank you. I don't have anything else to add.
And I'll just state for the record, Mr. Takei, and it is based upon, our recollection, but that's not the only reason why your request is being denied. And again, I point out in 89.9 F2, the first requirement in that section is the establishment of procedures by the employer. And for the DOE to claim that they were unaware of that issue, that issue would be raised in this case, like I said, rings hollow. I mean, it's plain as day in the statute. It's been raised throughout this case. It's the same thing that I told you yesterday. And so, again, for the reasons that the board's already mentioned, your request is going to be denied. And we'll deal with Mr. Alapa if and when that arises regarding any witness. But do you have any other witnesses?
I do not have any more witnesses subject to the reservation of right to call a rebuttal witness based on the complainant's case against the union.
Okay, but at least as far as for purposes of this phase of the case, it's not overall, but for this phase of the case, you rest.
Yes, I do.
Thank you. Any issues before, any other issues, I should say, before we proceed with the case against HSTA?
I would like a point of clarification for a decision made at the end of yesterday. Mr. Lapa made a motion to dismiss the charge from their case. We haven't had their case yet. I think my recollection is he said that we didn't present evidence for a charge, but we haven't had his case yet. And that seemed odd to me. I don't really know how this works, but that seemed.
Mr. Reid, Mr. Alapa withdrew.
Oh, he withdrew that.
My recollection, Mr. Alapa, you can correct me if I'm wrong, that you, based on the testimony and the clarification, I believe Mr. Alapa withdrew his motion.
I think there was another one with regards to the last statement of issue, the one that mentioned possible discrimination.
Yeah, he's correct, board member. I withdrew my motion, motion to dismiss the 89F2 versus 89F1 claim. I did withdraw that one. But I did make a motion to dismiss the claim that the HSTA discriminated against the complainants based on coming from the mainland portion. And the basis for my motion was that all three complainants testified and conceded that the basis for the compression fix was not based on their ethnicity, their race, where they're from. They all admitted to that. In fact, one of the complainants, Ms. Campbell, testified that her non-BU5 experience was from Honolulu at Sacred Hearts. So based on those representations and admissions, I moved to dismiss issue number 7 related to discrimination. And I understand Mr. Reid's objection because this isn't our case in chief, but this is a unique process that we're employing that I've never experienced also. So if it's not appropriate now, I'm going to make that motion later. But I think that based on the testimony that's been provided, which I'm allowed to rely on, I think it's appropriate at this time to get rid of that issue so we can focus on what's left. Thank you.
I don't believe in the course of the pleadings or in the course of this hearing, we have mentioned the word race. I don't believe we've mentioned skin color because that is not exactly that is his interpretation of what the charge is. For clarification's sake, it is our position that both the DOE and the HSTA discriminated against a class of teachers with prior experience. It's my understanding based on board orders that the board takes a wide they don't strictly use like the federal classes for discrimination. They take a wider view on what groups of people are. And our position isn't based upon race, skin color. It is based upon there's a class of teachers, which we're all a part of, which had prior experience. The DOE made a choice to take that class of people and take away their experience. And it is also our claim that action had a disparate effect on people from the mainland.
Mr. Reid, just for a point of clarification, that the only party I just heard you mention was the Department of Education.
Oh, and yeah.
Right. So, Mr. Alapa is making the motion on behalf of the Hawaii State Teachers Association. So it's HSTA.
Well,
is it your same position?
I meant both. I meant both the union and the employer.
Mr. Alapa, I understand your arguments, but because of the procedure of this case, I'll find that maybe that's a motion more proper after we delve into the HSTA portion of the case, which I believe we're about to. So you can renew the motion at the appropriate time.
Yeah, understood. And just if I can, for the record, show a point of clarification. The discrimination claim is only against HSTA. That's issue number 7. I don't see that discrimination claim against DOE. And also, they specifically say it's discrimination against a group of teachers from the mainland portions. So just for clarification, thank you.
No, I understand, Mr. Love, that's why I asked the question about only the mention of the Department of Education. I wanted to clarify.
Thank you.
I apologize for the details, but that's my position.
Mr. Takei.
Sorry, I just wanted to get clarification on one related point. Mr. Alapa just now, and I believe yesterday, asked if the union can rely on testimony and stuff that were presented in the complainant's case against DOE. Does that equally apply to the DOE as well? My understanding, at least, is that the DOE can also rely on the testimony and evidence provided going forward that may arise in the complainant's case against the union.
Yes, Mr. Takei. Well, we're utilizing a certain procedure to try and make this more efficient. It still is one case. And evidence being presented is evidence being presented, and all parties can rely on what evidence is admitted and what evidence is presented before the board.
Thank you. Thank you. Just for clarification, no,
Sure.
oh, I'm asking. And yeah, throw me out yet. The Department of Education can't call more witnesses, obviously, and in the case in chief against the union. Well, I guess, I wasn't fully informed. I had a thing, and then you addressed it, and then
No, Mr. Reid, what Mr. Takei is saying is the same thing that I said to Mr. Alapa. Whatever evidence that's presented in each of their cases that's admissible can be relied upon by any of the parties. And that's what the ruling was for Mr. Alapa. Mr. Takei has made the same request, and I granted that. And the same would be for all three of you, that you can rely on evidence in either one of your presentations.
I understand that. I mean, I guess my concern was that allow a second chance to
We're not at the issue of calling additional witnesses or rebuttal witnesses. That wasn't the point of the request. So that issue hasn't been raised as of yet.
Thank you.
Okay. So Mr. Reid, are you ready to proceed with the case against the Hawaii State Teachers Association?
I am.
And you may proceed. Who's your first witness?
We call Andrew Eshelman to the witness stand.
Okay, thank you. Ms. Eshelman?
Are you gonna ask me contract questions?
Not
Yeah,
many.
okay. Oh, thank you. Good morning.
Good morning. I just remind you, Ms. Eshelman, you're still under oath.
Yes.
Thank you, Mr. Reid. You may proceed.
Can you refresh us on your educational background?
I have a bachelor's in social science education.
And would you also refresh us on your legal training?
I've had a variety of legal training through my work at the Hawaii State Teachers Association since 2004. And you may be aware that I've been in law school since 2020.
Did you omit that from your, did you omit the fact that you were in law school from your testimony on Monday?
Objection, argumentative, lacks foundation.
Mr. Reid, I don't know where you're going with this. Just ask your questions.
Okay. Does being in law school enhance your knowledge and application of the law above that of a layperson?
You talk really fast, I didn't hear.
I'm gonna object to that. That's vague and ambiguous as to the terms layperson, enhance, lacks foundation.
Can I just respond?
Well, I'm going to say, Mr. Reid, you need to lay some type of foundation that what knowledge or experience Ms. Eshelman has in the law. So you are making assumptions and using some vague terms in your question. So
yeah.
If you can try and rephrase the question.
What is it that you study exactly at the University of Hawaii?
I'm in a standard judicial doctorate law program.
And during the course of your studies, you learn about jurisprudence and how the law works. Is that correct?
That is part of the study of law.
If I can offer, board member, sounds like they're trying to qualify her as an expert in law and the collective bargaining agreement, collective bargaining laws. That's what they're trying to do. I'll stipulate to that.
Mr. Reid,
That's fine. Well, or
do you agree to that stipulation?
that she, yes.
Thank you, you can proceed.
Uh,
Thank you, Mr. Alapa.
Were you the primary supervisor regarding the HSTA's interactions with the DOE during the creation and implementation of the compression fix?
I am the chief negotiator for the association.
Um, why does the union exist?
I'm sorry,
Sorry, why does the union exist?
I mean, overly broad.
What's the primary function of the union to your understanding?
primary function of the union. Are you asking me under state law? Are you asking me as a nonprofit organization? What are you asking?
As a teacher advocate,
The teacher advocate.
what
I'm not sure I understand the question.
does the union negotiate the working conditions and the rights of the employees?
HSTA
Yes.
is the exclusive bargaining agent of bargaining unit 5 employees under state law.
And is it a role of the union to make sure the employer follows laws and the CBA?
As the exclusive bargaining agent or exclusive representative, we are responsible for contract enforcement.
So is your testimony that you don't look at the actions of the employer through the lens of
I didn't
following
say
the
that.
law?
The
That's what I'm asking.
Black's Foundation argumentative.
Yes, I'm gonna sustain the objection, Mr. Reid, and maybe you can rephrase your question.
Do you consider the implications of the law when you observe do you consider the law when you observe the Department of Education's actions?
I'm gonna object overly broad as to the term law. There's a lot of the laws out there. If he wants to be specific as to what law he's referring to, I withdraw my objection.
Chapter 89.
Could you repeat the question,
Yes.
please?
Does the union act as a check and balance against the employer's actions with regards to Chapter 89?
I'm gonna object to the term checks and balance, Black's Foundation. It's not an appropriate term for collective bargaining.
Mr. Reid, you need to narrow down your question to Ms. Eshelman.
Gonna make me-
I'm gonna allow you to try and rephrase it
Okay.
one more time,
Um,
as soon as Mr. Hirata.
I'm getting adjustments here.
I think we're all set.
Okay.
Our engineer did his adjustments. So,
Apparently I wasn't quite in the shot.
Mr. Reid, you proceed.
are you in a position in the union to be part of the process that could file a prohibited practice complaint against the state?
As the chief negotiator and the deputy executive director, I oversee all bargaining unit advocacy and contract enforcement. So yes,
So that would include impact bargaining,
yes.
and that would include demands for negotiation,
I'm sorry.
and that would include demands for negotiation.
Yes.
Um, this is a contract question. Article 24, 25, but the
I
25.
didn't bring my contract.
So it's-
Allowed to grab my copy of the contract.
Yes. Ms. Eshelman, if you can just show it to Mr. Reid. Okay, thank you.
Ms. Eshelman, can I have my copy of the?
That's all.
Yeah, thank you.
Article 25 speaks to
25, you said? Sure.
Yes.
Maintenance of benefits?
Yes. It's,
That's not the
Oh.
contract that I understand this case is related to.
sorry. Yeah, 21. 21, 23.
Wait, 20,
The 21, 23.
okay.
Paragraph A speaks to rights, benefits, and privileges pertaining to the conditions of employment. What does that mean to you as the chief negotiator of HSTA?
Article 25, maintenance of benefits, letter A in contract language has to be read in its entirety. You can't just extrapolate. Is specific to the benefits and the standard practices, or some people call it the school code. So that provision, letter A, is only related to the school code.
And school code would include 5200, which is the human resources. It contains the laws about pertaining.
The 5000 series is part of this, the school code or the standard practices, yes.
Do you recall our previous testimony with regards to the timeline of the legislative history and the creation of the repricing, the creation of the compression fix that we had on Monday?
Could you be a little more specific?
We discussed, I just look at the questions, it'll be easier. In 2019, the pilot project, sorry, if you look at the exhibit, RU1. Let's completely do it this way.
The December 5th, 2019 memo?
Yes.
Okay.
The end. It states that
Wait, which page?
Hold on, Mr. Reid, what page?
the 10.
10, okay, I'm there.
Sorry, is that C10?
U10.
U10.
Yeah.
Yes.
Okay. The last paragraph talks about the department's intention to do a pilot project to address teacher salaries. Did the union advocate for that action?
What action?
The action to create a pilot project to address equity and compression in teacher salaries.
The union has advocated for probably close to 20 years to address compression. We did not advocate for a specific pilot project or a specific vehicle. So to answer your question, no, we did not advocate for a pilot project.
What did you advocate for?
Addressing compression.
Your intention when advocating to address compression was the creation of what exactly?
Was for some sort of salary adjustment that would occur to reset folks more equitably across the salary schedule, which I believe is outlined in the final plan that happened in October of 2022. And there are charts in it to speak to that.
And is that not similar to what is being discussed at the last paragraph of U10?
I don't know, because this was just an outline primarily of her plan, the superintendent at that time, Kishimoto's plan to implement shortage differentials. And that last paragraph was her reference that in the future she was planning to do something. But it doesn't really speak to the full plan.
Okay.
Her full plan was never implemented.
So let's move to C0009.
Okay.
The first paragraph in the executive summary speaks to concerns reported by the Hawaii State Teachers Association with regards to the creation of an EMP. To the best of your knowledge, did the HSTA report concerns to the department that resulted in this EMP?
I think I've already testified multiple times. We had been advocating around this issue for close to 20 years. So it's not specific to an EMP. It's not specific to a repricing. It's specific to the problem. And we were looking at multiple options to resolve it.
And in this particular case, talked about in January 16, 2020, in this specific instance, this is what the employer was doing in response to your concerns, correct?
Yes, this is one of the things that Kishimoto was looking at around teacher compensation. There was actually a much larger conversation around salaries, around compensation. This particular superintendent had a number of efforts that she was working on. We just spoke about one of them, which was shortage differentials. So she did a comprehensive salary study when she first came into her position, and that was part of the data that was used to make decisions around what kind of adjustments needed to happen.
To be clear, the DOE didn't communicate, or did the DOE communicate to you repricing in the year of 2020?
Year 2020. No, this superintendent never brought up repricing with us.
Same question in regards to 2021.
2021. No, we were dealing with COVID. All conversations ceased for about 2 years.
That's in on or around January 21st, which is, if you turn to page C16.
21st of what year?
2022.
22. Okay.
On or around January 21st, 2022, had the conversation restarted about how to address teacher compression with the DOE?
I wouldn't say necessarily restarted. It's been an ongoing and continuous conversation.
You had just mentioned that it stopped for a while during COVID, so I was going to be clear.
Right. I mean, the thing is that if you're asking me, were they talking to us about repricing? No, they weren't, right? People were talking about pay cuts and furloughs and layoffs in 2021. So if you're asking me, did they come to us and like say, we now want to reopen this conversation? No, it's something that we have continued to advocate for.
And you anticipated my next question. Did they discuss repricing with you around January 21st of 2022?
I do not recall that we had a repricing discussion in January of 2022. No.
Same question for March.
I don't recall.
Same question for April.
I don't recall.
Let's look at.
I will note, just for the record, you're referencing legislation. I do not typically handle lobbying at the legislature. It's very rare for me to testify. On occasion, I'll be brought in on a very specific collective bargaining matter. So I'm not really the person that can testify to what was going on at the ledge and conversations around legislation.
My questions really weren't about, I was using that date reference as the conversation was continuing with the legislature. So the conversation may have been continuing with the Department of Education, the HSTA. That was a date reference more than anything else.
Okay.
The CU 1. Actually, not exactly 1. Oh, well, yes, the date on this member matters email is May the 3rd. Do you see that? Okay. And if you turn to 2, we now see the introduction of repricing. Do you in the 3rd paragraph from the bottom, do you see where it says the mention of repricing?
Yes.
And how it says that this is the term we're using this year? Language, I think it says language.
I'm sorry, where are you referring to?
The second line, that's the type of language we're using this year. The first and second line.
I'm sorry, which paragraph am I looking
The
at?
third from the bottom starts with the governor and the executive.
Yes, I see the quote from Sylvia Luke. Yes, I
Yeah.
see that.
So they just say aware of repricing on or around May 3rd, 2022.
Ask the question again. Were we aware of?
Were you aware of the DOE's efforts to reprice on or around May 3rd, 2022?
I was aware that there was a decision by the state of Hawaii as it related to the legislature that they were going to offer up funding for, and the mechanism was going to be a repricing, yes. If you're asking me, had the DOE come to me with a comprehensive plan in May? No. I think it's really important to differentiate the role of the legislature, the role of the Department of Education, the role of Office of.
My
Collective
question
Well,
was about that.
Can she finish? She's addressing his question. Yeah.
Yeah.
Can you finish your answer?
Yeah, I think it's important to differentiate that my primary interaction is with the Department of Education or public charter schools. My primary interaction is going to be with Office of Collective Bargaining and those representing the state of Hawaii and the Board of Education at the bargaining table or in consultation. I think it's important to understand, like, this is a quote from at that time a representative of the legislature, right? Who then went on to become, obviously she's lieutenant governor now, but what the legislature does and then what the DOE does, at that point, that's when I get involved. The DOE will contact me and we'll have those conversations. So just to be clear, right? And I didn't write this. This is something that came out of the organization, not me.
Yeah, I'm probing the union's awareness of repricing as it was used.
So I will absolutely testify. This is a communication we sent to members in May of 2022. This is not a made up communication. So yes, we were aware that the legislature had decided to put money in a bill to, and the vehicle that they had put into the language was repricing. Yes.
All right. Let's look at C006, C6. Oh, I don't need to ask that question. Does the HSTA lobby members of the legislature?
Yes.
Yes. Would you describe the HSTA's lobbying efforts as infrequent?
Lobbying efforts is infrequent. I can testify that I know that we have staff and we have leaders who are down to legislature on a regular basis during session, speaking on behalf, testifying on behalf, submitting testimony regarding bills.
So you have a staff dedicated to this task?
We have a full-time government relations person who's a professional staff employee of HSTA. And then during the legislative session, we have a minimum of one teacher who is out on leave, and they help monitor the bills. And then we have a lobbying team, which is consisted of our executive director and our state officers, as well as our chair for our government relations committee.
Okay.
And they're all down there at various times, monitoring bills, testifying, talking to legislators.
Okay. Also a few questions. For the sake of being explicit, was the salary compression fixed through repricing?
So salary compression fixed through repricing.
Yeah. Or I could say addressed. Nothing's ever truly fixed.
I believe I believe yes. Yes,
Okay.
the salary schedule was the distribution of individuals on the schedule was moved to a point that the compression had been addressed. Yes.
Would it be fair to say that repricing was done to solve the problem that the HSTA continually brought up to the employer?
Yes.
Does the union work very closely with the Hawaii Department of Education in regards to any plans relating to the wages of bargaining unit 5?
I'm not sure what you mean by works closely. We regularly communicate with them regarding collective bargaining matters, including wages, yes.
Was it your testimony earlier this week that the union was not in any possession of any documentation from the DOE that would indicate the existence of any established procedures within the Ohio Department of Education to periodically review the repricing of classes within bargaining unit 5?
I believe I testified that I wasn't aware of any documents earlier this week, yes.
Was it your testimony earlier this week that the Ohio Department of Education has not ever given the union written documentation that was specifically created by a periodic review of the repricing of classes?
That's a long question. Can you read that one
Yeah.
more time?
I'll go slower and less pauses. Was it your testimony earlier this week that the DOE has not given the union written documentation, a report that was specifically created by a periodic review of the repricing of classes?
I don't recall if I actually testified to that earlier this week. So are you asking me?
Yes, I'm asking you now, yeah.
And I'm just gonna object to the term report as vague and ambiguous, because she did testify that data was provided. He's referring to a formal report. If you can clarify that, and I withdraw my objection as being vague and ambiguous.
Formal report.
So, are you talking 2022? When are you talking?
Yeah, 2022.
So I can testify that there was a lot of data being reviewed, related to salaries. Much of the serious discussion that started was with Superintendent Kishimoto and a comprehensive salary study that she did, and we actually contributed to that salary study in 2020 that came out. And then building on that data and information, we continued to get additional data related to collective bargaining into 2022 at the time that there was a repricing discussion.
Was it your testimony earlier this week that the HSTA does not have a written agreement with the Department of Education so that they can evaluate the repricing of classes less frequently than once each 5 years?
Do we have a written agreement? Say it one more time.
Yeah. Was it your testimony earlier this week that the HSTA does not have a written agreement with the Department of Education so that the DOE can evaluate the repricing of BU5 less frequently than once every 5 years?
I don't recall if I testified to that earlier this week, but there is no written agreement to allow the DOE to reprice less than 5 years, less frequently than every 5 years. There is, to my knowledge, no agreement to that.
Okay.
And just for the record, I want to object to how the question is asked, to the extent that it's representing what this statute actually says. I just want to make that objection to that extent.
The objection is noted. Hey, Mr. Reid.
Okay. Approximately when did the according to testimony heard earlier by Mr. Bacon, the HSTA agreed not to include the 6 years in repricing. Is this true?
Are you talking about the 6 years of outside experience?
Yes.
HSTA never entered an agreement, as Mr. Bacon testified.
Was there by entered into an agreement, do you mean a written agreement?
No. There
You
was
mean-
never any agreement with the Department of Education to say, yeah, we're good with that. There was an acknowledgement that they had a right to, under F2, to implement what they were doing. But there was never agreement. We continued to tell them that this is a concern and that it should be addressed, and that is why we brought it up in bargaining.
Okay. That. Look at C0006.
C 006
Yeah,
in there.
C6. You had previously asked for compression to be addressed during negotiations for CBAs in the past. Is that correct?
I can testify that the HSTA has done proposals in the collective bargaining process to address compression. Yes.
Were those do you have knowledge that the union specifically communicated with Sylvia Luke with regards to legislation to fund or put a vehicle in for the compression fix regarding the compression fix?
I can only testify that I know that there was lobbying that occurred. I can't testify to specific conversation.
Okay, so you'd say the same thing about Donovan Dela Cruz?
Yes, I'm not involved in those direct conversations.
Let's turn to 89.9. It's not an exhibit.
Something here, 8913.
Yeah, I think there's some copies of the
Which section?
89.9 F.
Do you have that in session?
Yeah, there's not one over here.
I think they have one.
I used it.
Yeah. Oh,
89.9.
It should.
This
be-
is 8913.
13 only.
Let me double.
there's
check
another paper for
if
the time.
it's up in here.
I mean, I have the.
I can bring it up on my computer.
Hold on. I know we had it yesterday.
I know there was one
Well,
other day.
here you
Yeah.
go. I mean, this is the.
Is that the most current copy?
It's the same.
Okay.
I mean, it's. But. 2012.
You know what, while we're sorting this out, we'll take a 10-minute recess. We'll stand in recess.
Oh, here.
We've been going for 2 hours and we're out.
We're rolling.
Back on the record. Reid, you were questioning Ms. Eshelman. You can continue with your examination.
Are you familiar with 89.9 F1 and F2?
Yes.
Can you describe to me your understanding of the differences between F1 and F2?
Primary differences are that F1 is a bargaining process where of repricing, and F2 is within the exclusive purview of the employer.
Can you tell me your understanding of the requirements present in 89.9 F2?
Yeah, I look at the. So, I mean, without reading the language, obviously, there is an obligation of the employer to periodically review salary and to look at whether there's a need for repricing. And the repricing is supposed to be based on that.
Is there any mention of how to do the review?
Once every 5 years? Is that what you're referring to?
Is there a requirement for the employer to establish procedures to make a review?
Well, the law says the employer in each jurisdiction shall ensure establishment of procedures, so. Yes,
And was it the HSTA's decision that the repricing was legal under F2? Or sorry, let me ask you a different way. Did the union come to a decision? Did the union evaluate the employer's decision to reprice under F2?
did we evaluate,
Consider.
okay, what's the question?
Well, I'll start with that. What did the, I consider this better probably. Did the HSTA, actually, that's to go with my original one. Did the HSTA evaluate the employer's decision to reprice under F2?
Yes, I mean, it was a consultation.
So they communicated with you the reasons why they we're going to do an F2, but did
They did, yeah, so I don't have any information about the employer's thought process about why they picked one over the other. They communicated with us that they were going to do a repricing on F2. That was their intention, and can we consult on it? And then we had a series of conversations about what their plan would look like.
was it the union's understanding that a repricing would impact the wages of the bargaining unit?
I think impact the wages is a term that can mean a lot of different things. It was our analysis that it was not going to change the salary schedule. So that did not require impact bargaining.
Was it the DOE's understanding that the repricing would change the amount of money paid to the individual employees?
That is what a repricing is you reprice the individual to a different rate of pay for that individual. That's the very nature of what a reprice is.
Were you a part of the Were you part of the consultations when the Department of Education declared that they were going to reprice under F2?
When they declared,
But when they
What do you mean
informed
by that?
you, when they
yes,
communicated?
yes.
Okay.
I was part of the ongoing consultation regarding their plan, which eventually became, public in October.
Did the union consider? Well, let me go back a step. Is this the point? The consultations where they informed you that they were going to execute an F2 repricing. Was this the point where they informed the union that they were not going to consider the 6 years of prior experience?
So timeline wise,
And just for the record, I think he's referring to 6 years of non-BU five
Yeah.
experience.
Experience.
Just to clear the record.
Yes. That's
Yeah.
correct.
Yeah, that is correct.
just to be clear, I'm working on the assumption when we use the term 6 years, it is the 6 years of outside of bargaining unit experience.
That is correct.
Timeline wise, the Department of Education did not come to us until after the funding was actually signed into law, right? Or signed into it's not a law, it's not a statute, it was an appropriation. So that would have been sometime in mid to late July. There were preliminary conversations about, okay, the money is there. What is your, where are you going to go somewhere with this? Related to that, it was our understanding from our legislative conversations. Again, I was not directly part of that, but this is what was communicated to me from our ledge folks, that the 121 million was inclusive of funding to restore 21 hours of job embedded professional development, which is why the language in that appropriation speaks to both repricing and collective bargaining matters. So the parties, so we said, hey, we want 21 hours are restored. That's a priority. The school year is coming up. And so we spent the next few weeks doing bargaining on 21 hours. In the meantime, the department was doing whatever they were doing around their plan for repricing. And then sometime in, I would say probably early August, we had preliminary discussions where they started talking conceptually about what they wanted to do and what their plan was. And it was sometime around August of 22 is when we first were told officially that the measure they were going to use was service time in the bargaining unit. They were not going to consider anything outside the bargaining unit because there's many factors. It's not just people with prior experience. There are factors where we have educational assistants who have worked for, say, 10 years in the Department of Education, but not 10 years as a teacher. They might only be 5 years as a teacher. So there's a question about, do we give those people credit? There was a question about people who have been administrators and have done administrative work. There was a question about, is it state service? And the department was very clear, we're going to do bargaining unit 5. And part of their rationale was that, and that was the one thing they could measure. And that was what the funding calculations were based on.
So it's your understanding that you were told that the department was unable of measuring how many years of prior experience that they had credited their employees with?
Yeah, so from, I don't think this has been testified to yet, and perhaps for some context, right? So while the department does an initial assessment for initial placement on the schedule, those files are in each individual personnel file. Those years of service are not attached to any seniority report. They're not attached to any ERS report. And so there is no way for the department to quickly do a data pull and be like, okay, we've got this person with 10 years and they came in with, we credited them with 5 years of service. They literally would have to pull each and every person's personnel file to assess that information. It's not something that is tracked. It's not an easy data set to pull out. And so part of their argument was that, one, there was not enough funding to pay for that. And by our estimates and understanding, there was some other grievances and things that I was aware of. We know it was in the ballpark of about 1,000 people that probably were in service at that point in time with prior service. But how many years of prior service and the ability of them to pull that data for purposes of repricing, they represented to us that that was not something that was easily done. And it was not something that they provided to the legislature when the legislature was asking them for the data to be able to figure out the calculations of the 121 million.
So if I understand you correctly, the DOE said it would be very inconvenient to
They
pull the
didn't say
data.
inconvenient.
Objection, Ms. Day's testimony, argumentative.
They said it would be very difficult because they would have to pull the personnel records of every single person who had the prior service. And they would have to do an assessment and they'd have to see, was it 1 year, 2 years, 3 years, 4 years, 5 years, 6 years? And then they would have to add that to the data set they already had, which is their seniority list to pull automatically.
How did you make your objection to the decision not to exclude, how did you make your objection to the decision to exclude the 6 years of experience to the Department of Education?
We made it very clear that we thought that that wasn't fair.
Was this in verbal conversation?
Yes,
Was this in an email?
it may have been. I have not gone back to look for it. It may have been, but I think they were well aware that that this was likely a problem. The issue of prior experience is not isolated to the repricing conversation. The issue of prior experience and concerns about people coming in and potential leapfrogging over people in the system. And then the subsequent compression has been something that HSTA has been dealing with for decades. We have been trying to look at changing those things. And we have, for the last, since I've been chief negotiator, we have been putting proposals in the contract to try and address the fact that we need to attract more people from out of state and increase the number of years. But one of those factors is it's very hard to cost. It's very hard to figure out because this DOE does not have good data on it. And it's very costly. So it's not unique. This issue of prior experience and how you address it is not unique to this compression repricing conversation. So the department is very well aware.
I want to speak to the issue of the issues of prior experience in the past because the department was unable to remember. Can you tell us why the years of experience, the years of prior experience is limited to 6 years
No.
upon reentry?
That is something that was put in the contract decades ago. I think probably around the time I was like 5 years old.
So
In the it goes back, those school
69.
codes, yeah, it goes back,
69.
it goes back like 40, 50 years.
Yeah.
I'm not exactly sure. I'd have to go look in the contracts.
My reading of it is it's about 1969.
There you go. Before I was born.
Me too. So
So I don't know why 6 years. I have no.
you have
subject
no idea
matter-
why, you have no idea why the limit is 6 years.
I have no subject matter expert on that.
Do you understand, or what's your understanding of how many steps are credited for those 6 years when someone is entered into the salary schedule?
So because since the late 70s, when the legislature took automatic annual increments out of the schedule, and they took it out of the purview of the law and put it into collective bargaining and said, you now got to go bargain these things because we now have this collective bargaining law. When that happened, the schedule has changed multiple times. The amount of step movements that have been bargained have changed over the years. Sometimes we get a step every year. Sometimes we don't get any steps, like between 2008, 9 and 2013, we got none. It's all over the place. And so those dynamics affect it, right? And so that's kind of what happens.
Is it, yeah, I'll clarify. Is it your understanding that when a teacher enters a salary schedule, that they receive as many steps as an incumbent teacher would have received during those same past 6 years?
Yeah, so what they do is there is a chart. We actually refer to it as the 1995 chart because that was the point in time when they did a reset of the schedule, and so they did a reset of that chart anyway. And that chart tracks where someone coming in with 0 years of service will be, and then you have to go back. And every single year that has to be reassessed because we don't get steps every year.
And is that reflected in CU 17?
CU 17 is what reflected?
The
CU.
for the year,
Oh, sorry, I was looking at U 17.
yeah, my exhibit 17, yeah, C,
Wait,
well, sorry, 88, C88. I got two, I got what's the.
hold on. I'm
the
sorry.
beginning.
Yeah,
What am I
C88.
looking at?
C88.
C88, okay. Here,
Is that, okay,
Hold on, give her
Okay.
time to get there.
okay, what's your question?
I guess this would be the last year, but is this the, I'm sorry, the C89, next page. C89, is that the chart that says that how many steps per year of prior experience was given for the 22-23 school year?
This is not the 1995 chart, no.
Yeah, it's not the 1995 one, but for the year 22-23,
So I can testify to this in regards to this document. The document that is outlined in C88 and 89 is a document that the department has used in some form or shape similarly for probably maybe 15 years. It's looked like this kind of configuration. This is a recruitment document. This is not something that is consulted with us. This is not something that is bargained with us. This is not something they send to us to review. They use this to recruit. I can also testify that on occasion, we have had to go back and tell them that this document is improper and does not accurately reflect where people are supposed to be placed, and we've had some grievances related to that. But generally, it should tell someone, yes, if you have this many years of service, you'll be placed here. And if you go back and look at each year, it's gonna look different depending on when you go back 1, 2, 3, 4, 5, 6 years, how many steps have happened.
So the initial placement of the employees with up to 6 years of prior experience could vary based upon how many negotiated step increases happened in those past 6 years.
It does, yes.
Um, okay. Did the union, so switching back to F1, F2, but thank you for the clarification on those points we couldn't get yesterday. Back to F1, F2, did the union ever consider that repricing may have been improper under F2?
May have been improper. Can you maybe be a little bit more specific?
Did you,
I'm not sure what you're asking.
Did the union, let me go back a step. When the union was informed that there would be a unilateral F2 repricing, was there any desire to have your voice present in negotiations via F1?
Or voice present in negotiation. What do you mean by that?
We're gonna object to just last foundation.
Okay.
Being ambiguous.
You can rephrase your question, sorry.
Does the union want their voice heard in matters relating to wages?
Objection overly broad or being ambiguous.
If you can be specific, are you asking regarding F2? Is that something, or F1?
But the answer was in general, so I guess I'll pick one. Okay.
I think if you specify what you're asking for, that Ms. Eshelman will be able to respond.
Well, I'll go back a little step. Does the union negotiate wages?
Yes.
Does the union value their opportunity to negotiate? Do you as chief negotiator value your opportunity to negotiate wages?
Objection vague and ambiguous as to the term value, irrelevant as it pertains to the issues in this case.
I can rephrase.
I'll let you rephrase, Mr. Reid, but yeah, it's the relevance is.
Well, I'm laying a foundation right now.
Well, I'll let you proceed, but I'm just saying that get to your point.
Okay.
That you're trying to make.
Did the union consider asking for a repricing under F1 because wages were going to be impacted?
I can testify that the union considered whether we wanted to demand impact bargaining or whether we wanted to demand bargaining it altogether, regardless of F1.
And what was the conclusion of, or what was the decision of that?
I think I spoke a little bit to this earlier this week, but all the factors considered and looking at everything in the situation, we were under the understanding that if we were to pursue a demand for bargaining, that the employer would withdraw. they were not interested in a protracted bargain. We also recognized that it potentially was this once in a lifetime opportunity to get an infusion of approximately $55 million into the pockets of our members, over 9,000 of them, in advance of the next contract. And so we had this opportunity to get a huge pay raise for a number of people, or a huge adjustment for a number of people, and then turn around and bargain even more money. And that if we demanded bargaining, it was very likely that the employer would say, never mind, we're not interested. We're only interested in using this money for repricing, because this is what the legislature gave us for repricing. And they gave us money for 21 hours. And this is what we got. And so, you know, we weighed all of those factors and we took all of those things into consideration. And we did not feel that it was prudent to walk away from that opportunity to do that reset. So we did not demand impact bargaining specific to repricing.
Right? During, because, well, the state has testified that they consider the repricing classes during negotiations and negotiations under under CBA negotiations. And under Chapter 89, negotiations have to include a written agenda. Is that correct?
I'm gonna
I'm
object.
sorry, that's like a long
Sorry,
question.
sorry,
Yeah,
sorry.
I'm gonna object on compound
Yeah.
using Black's Foundation. And I think it misstates the law if I'm thinking he's referencing a certain part of 89. So I'm just
8910.
needing some clarification on that.
I'll read it.
Yeah, and Mr. Reid, I'll simply add that I don't think it's disputed by any of the parties that there were negotiations.
And that's correct. We stipulate that there were no negotiations in this case.
Not to
So-
repricing, yeah.
So I'm struggling a little bit with the relevance of the negotiations, but
Can I address that real quick? Sean Bacon testified that the DOE, as a part of negotiations for the contract, accomplishes a periodic review for pricing. And there has to be a written agenda according to, I think, 8910 for all official negotiations. And I'm asking if the DOE ever put that in the agenda.
I think that's a different question from what you were asking.
Maybe I
So, yeah, I'll
didn't
let you go
communicate
ahead and-
I
properly.
have no objection to that question.
Right.
Okay,
You can
so-
go ahead and ask that question.
Yeah, can I ask a couple clarifying first?
Yeah, sure.
So you're asking me in bargaining
Yes.
for in the last round of bargaining,
Well,
which would have been a fall of 20, like summer, fall of 22 into 23, that's
Sure.
the bargain, okay? Was the word repricing? What are you asking? Because we look at data, we look at
Yeah, yeah.
salary,
Uh,
so.
there is an agenda has to be agreed upon for bargaining. Is that correct?
Our negotiation rules are such, yeah, that we agree on a joint agenda. It doesn't have to be written necessarily, but we agree on a joint
Okay.
agenda of what we're gonna talk about in the sessions, yeah.
And on that joint agenda,
Huh?
have you ever seen repricing mentioned?
The word
The
repricing?
word.
No,
That's
not
my
the word
question.
repricing.
Okay.
We look at data, we look at salary, we look at where things stand, but not specific to repricing,
Okay,
the word, no.
that was my question. I apologize for my struggle to
No, it's
speak
okay.
legalese.
It's a confusing topic.
Okay. Okay, so just to be clear, when the DOE I guess proposed, implemented, informed you of the unilateral F2 repricing, the union is it my understanding? Well, the union didn't take any official action to stop it because they wanted the greater good. Is that your testimony?
I'm
Probably.
gonna object to how he phrased it. She
Yeah.
gave a pretty substantive answer to that.
Well, yeah.
I think that omits a lot of what she said, so object as an answer and misstates her prior testimony.
Yeah, I'm gonna sustain
Okay.
that objection, Mr. Reid.
I think it's been clear. Okay. To this day, has the union ever publicly stated that they were against removing the 6 years of prior experience?
Well, I'm gonna object, Lax Foundation, there was no removal of the 6 years of prior non-BU5 experience. She's testified that the original proposal by the employer did not include that, so nothing was
Oh,
removed.
I'll
The Lax Foundation that it was removed in their cases, and we'll provide testimony that states that.
I'll rephrase. Has the union ever publicly stated that they requested for the 6 years of prior experience, non-BU5 experience, to be included and were denied?
I'm gonna object, as being vague and ambiguous. I think we can all agree that in these proceedings, that has been our position in writing, in our motions and in our testimony. So, misstates,
I'll
it's
rephrase.
vague and ambiguous as to what the scope of his question pertains to.
Does the union communicate with its members through through periodic emails?
Yes, we have a weekly email.
And these are the member matters emails, correct?
That's the term that we call them, yeah.
And the union has communicated a lot of information about repricing through members matter emails, correct?
Yep.
Has the union's position regarding the 6 prior years ever been stated in a members matter email?
Which position?
That you wanted it to be included in repricing?
I'm gonna object as to, foundation, it's vague and ambiguous because there's actually concurrent processes going on at the same time with repricing and active, CBA negotiations, which she alluded to, which involve the 6 years of non-BU time. So the Lax Foundation, vague and ambiguous as a scope.
Mr. Reid, I think for these emails, they're not, at least from your C1 that you put in there, these aren't from Ms. Eshelman herself, right? It's from the association, so there needs to be some type of foundation or context with what you're asking of this witness, that if she even knows who, I'm not trying to tell you how to present your case, but you need to lay some type of foundation with the witness.
Are you involved with the information that goes into the members matter emails? Like, or can I just,
Sometimes, yeah.
can
Sometimes,
I
yeah.
just refer to them as emails?
The member matter emails,
Member matters,
yes,
I'll call the member emails, less syllables.
that's fine.
I get twisted. So you are, so sorry, just because there's some back and forth, you are sometimes involved with the creation of the member emails?
Yes.
Okay.
Well, I don't create them. I am sometimes consulted to review them, to review for content and accuracy.
Okay. Do you know about how many recipients receive the emails?
I think our email list serve is about 12,000.
To the best of your knowledge, have you ever seen, well, when you review and do what you do with the member matters emails, to the best of your knowledge, have you seen the position, or have you seen it mentioned that the union requested for those 6 years and the state said no?
I know that we have communicated that the state was unwilling to do that. I cannot recall specifically as the way you phrased it, that we requested and they said no. I just don't know. I review thousands of pages of stuff every week practically, so I don't recall if it was phrased in that way.
Okay.
I know we communicated it to the members that that the state, or I should say the DOE was unwilling to recognize non-BU5 experience.
And you mentioned that you periodically review the emails for content and accuracy. So is
Correct.
okay.
Mhm.
Do you when you review the emails for content and accuracy, do you intend for the members to reasonably rely on the member matters emails?
Object, vague and ambiguous as to what reasonably relies on means. It's just a way to communicate information. I don't know what context he's referring to as relying on, just a way to share information. And also, she's testified that she doesn't review all of them. It's whenever she's needed. So sounds like this is a more generally applicable question. There's no foundation for this witness to answer.
Well, I think I said when she reviews.
I mean, rephrase your question.
Okay.
Mr. Reid.
To the best of your knowledge, is it the union's intention for the information in the member matters emails to be accurate?
Is it the intention for us to have accurate communication? Yes.
Let's look at C99 and 90s or 96. I forgot what it's here.
90.
What page, Mr. Reid?
Yes, C90. It'll be CU20. The top number.
Oh, wait. C or U?
C98.
C98.
At the top.
Okay. Okay, what am I looking at?
The sixth paragraph beginning with Hayashi's memo.
Well, I mean, Mr. Reid, because the document doesn't start on C98.
Yeah.
We identify it, I believe it starts on C97.
Yes.
Identify what it is.
This is a this is a C97 is an article from the HSTA website. Can you?
Yeah,
Can you verify that?
it appears to be something that we publish on the website. Yep,
Okay. Posted September 30th, 2022.
that's the date. Yep.
If we turn to C98, the next page. I think 6, 1, 2, 3, 4, 5. The sixth paragraph starting with Hayashi's memo. Is the intention of this paragraph to does this speak to the fact that the HSTA collaborated with the government, with the Department of Education and the Department of Human Resources Development Office of Collective Bargaining and Budget and Finance in the implementation of the compression fix?
Objection lacks foundation as to this witness's prior knowledge or familiarity with this email. They haven't set a foundation. They want to just ask the question without referencing the email, that's fine, but there's no foundation for this email.
Sure.
I can't speak to the intention of a particular paragraph in a communication, but you can ask me the question just straight out.
Okay.
Mr. You can ask the question. Plus,
Just-
the board would note that this is a quote from Superintendent Hayashi.
So I can't
They
speak to what his
publish-
intention was.
Okay. let me shift gears real quick. Let's look at C96. Do you recognize this as an excerpt from the frequently asked? Right there.
I'm not exactly sure what it is.
There-
I'm trying to figure that out.
Do you recognize that this is an excerpt from the frequently asked questions from the HSTA website regarding repricing
I'm not
or the compression fix?
sure. Is this part of the article that starts on C90?
No, this is its own. This is just the one page. This is not attached to 97 or 95.
Okay, let me read it. Okay, this looks familiar to me. I know that that this topic is on our website.
Is it fair to say that these questions are designed to inform the members about the compression fix?
The
But
FAQs that we worked on and published for members are a byproduct of questions that we get from members. So this is a common practice that we do as one of the modes of communication and methods of communication to members. When there's a major thing happening, whether it's bargaining or something at the ledge or what have you, or some sort of news story. If we get a number of questions, we will then put together an FAQ to try and answer those frequently asked questions, in large part to help our staff and our leaders be able to answer those same questions as well, right? So that everybody has a common understanding of if you get this question, this is the answer. So it is one way to communicate. It's not the singular, but that is how we use FAQs in our communication.
so is it fair to say that you use the FAQs as a way to address concerns that the members have?
Address questions, not only
Questions, okay,
concerns.
yeah.
Yeah.
To address questions. Is it fair to say that a member could have a question about their out-of-year experience, read this, and then have the question answered?
Objection, improper hypothetical, calls for speculation.
I'm gonna sustain that objection.
Is it the union's intention for these FAQs to is it the union's intention that the members can rely on the accuracy of the information in the FAQs?
When we put together materials to answer questions from members, we always strive for them to be as accurate as possible.
The last two words, well, in the question, well, I'd like to draw your attention to the question says, will your years of service teaching out of state count? First paragraph, the last two words, this is a piece of paper, obviously you can't click on it, but are you aware that's a link?
Okay, wait.
Where's the state law?
It's likely a hyperlink. Our communications department, as much as possible, tries to provide those additional embedded links.
Okay.
I can't tell you where it goes to, but it's likely an embedded link.
Would it surprise you that the link goes to chapter 89, 89.9 F2?
No,
And
that's the basis of that sentence.
yeah, I'm just making it clear. And a little bit of additional information. Would it surprise you to know that when you click the link, it highlights a portion of F2?
I was just gonna Jack, he's providing testimony, number one, and there's no reliance on the evidence in the record or prior testimony to establish this line of questioning.
Okay, that's fine.
Yeah, Mr. Reid, there's no foundation or document or
That's fine.
anything to confirm where this goes.
And we have no problem agreeing that the state law that the employer reference is F2. So it's likely the case. So we have no problem agreeing to that.
Yeah.
Yeah.
And our communications to folks reference that, so that's,
That's all, yeah. The answer to, well, the only question I'm concerned with on this paper is the one, will the years of service teaching out of state count? In the second paragraph, it says that initial hire placement does not provide service credit. Is that accurate?
correct. It does not provide service credit.
Okay.
Service credit is used for primarily two things, which is seniority, primarily for staff reductions, but some other HR decisions, and then ERS.
Yeah. And state law is mentioned after that. You just addressed. Oh wait, yeah. Well, does this mention? This question addresses, or this this question references state law. Is it fair to say this question references state law to give it more reliability?
Objection, vague and ambiguous, cause for speculation, proper hypothetical, lacks foundation.
Yeah, Mr. Reid, I'm gonna have to sustain that objection. Maybe we can try another question regarding this.
The this answer also mentions the employment retirement system. Is that correct?
Correct.
And they're mentioning the employee retirement system in a question regarding out-of-state experience for the compression adjustment. Is that correct?
Yes, the reason that it's referenced there is to help provide further explanation as to what service credit is, because the time we were working through this, we're getting a lot of questions that people don't understand what service credit is. So we're trying to give further context. I think there's a lot of assumptions that are made by people who come into the state, and people understand what it is or come into service with the DOE and they think it's one thing, and but based on their life experience. And so we're just trying to make things clear and accurate.
To the best of your knowledge, in your role in the HSTA, have wages ever been tied to service credit before?
Tied to service credit before.
Or yeah, I'll rephrase. Have wages, sorry, has step increases ever been?
So
Okay,
step
yeah.
increases are tied to whether you're in service. Yes. So for example, the negotiated step increase that occurred at the start of this year, you had to, in order to qualify for it, you couldn't be a brand new hire. So that's tied to your service time. Board member, can I go put my phone on do not disturb? It keeps beeping on my watch.
Yes, it is.
Yeah.
It's very bothersome.
Yes.
Thank you. These text threads and it keeps buzzing and I'm like, this is very distracting.
Understand. Mr. Reid, you can continue when you're ready.
Other than the last one. Would it surprise you that BU5 members rely on the union for accurate information in their communications to them?
Objection, lacks foundation, proper hypothetical, speculative, being ambiguous.
Mr. Reid, if you want to ask for the three of you, for yourself, that's one thing. But to ask the question on behalf of all the members of HSTA, how they interpret something is pretty far afield.
Okay, I guess so. Is it the expectation? Did you or have you reviewed the information in this answer?
Yes, I reviewed all of the FAQs that go out.
Can I just object to, if they can just clarify, are you talking about before it's published or in preparation of this testimony? Then give us
Before it's
context.
published.
Okay, thank you.
Yes, the FAQs that we created as related to the implementation of the compression fix through repricing, I reviewed the FAQ.
Okay.
I will note, and I can't speak to it, that the FAQs have been updated over time, so I'm not exactly sure what's point is screenshot, but I'm not saying that, like, this is, I'm sure, accurate for whatever you pulled off the website.
So was your intention when you reviewed it that it would be accurate and true, correct?
Yes, absolutely.
And was it your intention when you reviewed this that members would rely on it to make decisions?
So the responsibility of the union as the exclusive rep is to represent employees, obviously. The philosophy of HSTA generally, the culture of HSTA is to communicate through multiple means and to try and make information available. If you're asking me, does the union say, well, this is going to be the only way we're going to communicate and this is, you have to rely on that? No. We provide information because we believe part of it is you folks members are highly educated professionals, and they like lots of information. And so this is one mechanism that we use to provide that information to them.
I wasn't trying to limit the mechanisms.
Yeah.
Okay.
So do we know that people look at our website and get information? Yes. Do we try to be accurate? Yes.
And this is just to make sure I heard you earlier in the testimony, just to be clear. Contrary to Sean Bacon's testimony, is your testimony that the union never agreed to accept the exclusion of the 6 prior years of experience in repricing? Is that correct?
Contrary to Sean Bacon's testimony that there was agreement between the parties. No, HSTA never said, yeah, we agree, you can do that. We made it very clear to them that we weren't happy about it. And we understood that this was the only way that they were going to implement it. And we understood that, but there was never quote unquote agreement. Now, for implementation purposes, that means that we have to explain things like this to people, right? For implementation purposes, when people call us and say, what's my seniority? And we go look at the data because they gave us a data set. We would say, well, this is what the record shows and this is what you have and so on and so forth. So we weren't trying to undermine their implementation or try to make arguments after the fact, but we absolutely never said, we agree. We agree that this is good, you can go forward.
Based on your interactions with Sean, well, did you have many interactions with Sean Bacon over the course of the implementation and the
Yes.
The process.
So we worked with Sean as the assistant superintendent. We worked closely with Naniola, who is their Nani Ole, who is their lead negotiator. We worked with Carrie Tom, who is in charge of records and transactions, which is the area of HR that deals with movements that have to happen. So when you get those Form 5s, that's his department. And then they in turn worked with their counterparts at Office of Collective Bargaining and Budget and Finance.
And is it fair to say that you and Sean Bacon communicated a great deal of the time? You guys were a part of the majority of the conversations regarding the compression fix.
Can you be a little bit more specific? I'm trying to understand what
Were
you're asking.
you on behalf of the HSTA? Were you at least 70% approximately of the conversations that happened?
If there's a meeting where Sean's at, I'm gonna be there.
Okay,
If that's what you're asking.
that's what I'm.
But that doesn't necessarily mean that Sean's at every meeting. right?
Exactly.
So we both have staff that implement things as well.
But you've seen Sean or Mr. Bacon a great many times with regards to the compression time.
There were numerous conversations and meetings related to implementation of the repricing, yes.
Based on the meetings that you were personally in with Mr. Bacon,
Mhm.
can you think of anything that may have occurred in the meeting that may give the impression that the union agreed to that the union agreed in the way that Sean Bacon says?
I think it's semantics of it. He's testifying, and I think based on the line of questioning that I've seen you do, is sort of this concept that we were in favor of, or we were like, thought it was great or good, that kind of agreement. Like we signed off and said, everything's wonderful. I think that's how he articulated it. However, I think agree in the sense that we're not going to go to the labor board and try and stop this. We're not going to demand impact bargaining. We're not going to jump up and down and say this isn't fair and don't do it. You know, that's another sort of like dynamic to that concept of agree. You're not going to find a written MOU on this because it wasn't negotiated. You're going to find a memo. So I think in fairness to the department, he can in confidence testify the union agreed to this because they agreed that we engaged in consultation over our unilateral right to implement a repricing under F2. You can even find a reference to the memo in October of 22 where they consulted with us. Yes, we consulted with them. We agreed with the general methodology of this makes sense to address the compression issue, to make this chart and do the 2-year P. Like those are things that we had discussions about. We advocated and said, you can't just do the one-time thing. You have to have a period of time where if people think that there's some sort of data error, they can appeal to the department. So we were the ones that got the email address and the appeal process. So you had all the way till May 1st to query and ask, you know, hey, I think there's a problem. Oh, I was on leave. Oh, there was this other dynamic. I was at a charter school. So, you know, we came to agreements on a number of things related to implementation. That does not mean that we agreed and thought it was fair or good to exclude prior service credit. So I think, you know, he can testify in good faith that he thinks that we agreed. But that's, you got to ask him, what does that mean when he says we agreed? Because you're not going to get something that says we have a written, you know, MOU that we negotiated. That does not exist.
Switching gears, the, are you aware of are you aware of the chapter, Facebook groups that the union uses for communication?
The HSTA chapter?
Yes.
Yes, I'm aware of them.
Are you in all of them? And is access to these forums for communication available to the public?
In some cases, yes.
Well, I'm gonna object to, yes, are you in all of them? Being an ambiguous, you're part of the group, I don't know what he's asking. He asked a second question after that, so if you could break that up.
Yeah, I don't know what that means.
There are some union people that are in all of the chapter
Well,
Facebook.
Would you like me to describe them for you?
What do you mean? All the chapters?
No, but the Facebook groups, is that what you're asking? What are
No,
you-
I'm
what are
just
you
asking
now?
if you're aware of them and if
I'm
you,
aware that we have chapter-based groups on the Facebook platform, yes.
okay.
I'm not a member of necessarily all of those.
If I could ask for an offer of proof, we spent quite a bit of time on communications to the members, and I think we've been pretty clear on intention is to be accurate, to provide the information, and that the information that was, at least in the question and answers, was accurate. None of the issues relate to issues with communications between the union and the complainants. It relates to, did the union have a duty to demand bargaining and stop the compression fix, and was there discrimination? Those are the issues. So I don't, if there's a tie somewhere, we spend a lot of time on communications. I'd like to request an offer of proof. I don't think this is relevant question.
Thank you, Mr. Reid.
Part of our claim is 893 rights of employees, and specifically, from memory, it's not going to work. I have it here. Specifically, our right shall have the right to engage in lawful concerted activities for the purpose of collective bargaining in this important part, or other mutual aid or protection free from interference, restraint, and coercion.
I understand what the statute says.
And how it means.
How does that relate to because I'm missing the connection.
I'm a participant in the Maui chapter, and I made an effort. I was involved in the word apology in concerted activities for the purpose of for the purpose of mutual aid or protection. I had a cohort. We were actually joined by social media, and I was asking for mutual aid and protection on that platform. And this is in regards to the activities that the union, I'm alleging that the union interfered with my ability to grow my concerted activity group for the purposes of mutual aid and protection.
I understand, Mr. Reid, but that's not what you've been asking. You've been asking general questions about the communication.
Yeah.
And what Mr. Alapa is asking for is an offer of proof of how you're going to tie it up, because as of right now, relevance is an issue because you haven't gotten to a point that you just mentioned.
I don't know how I should say it yet. I was banned. Well, no, banned is the wrong term. I was blocked from replying.
Yeah, I don't
on
want
the
you to testify, but if you're going to continue on this line of questioning, you need to tie it up
I
to
emailed.
some issue. And no, I don't want you to testify.
Yeah.
But you need to tie it up on relevance to one of the claims against HSTA, because right now, all I'm hearing is there's a Facebook platform, there's frequently asked questions, and there's no tie-in on the relevancy to your claims. I'm not asking you to tell me. What I'm saying is, in you asking your questions, you need to tie that up, because I'm not going to let this go on much further without the tie-up. Mr. Alapa.
And I wanna just respond to his reference to his claim of violation of 89-3. This is the statement of the issue related to 89-3. The union violated 89-3, and I quote, by not demanding negotiations or filing a prohibited practice complaint to stop the state from illegally repricing. That's what they provided in their complaint and in their pre-hearing statement as to what the issue is related to 89-3. It's not banning from Facebook. If that is an issue he wanted to raise, he was supposed to put that in his complaint and raise it as an issue in the pre-hearing statement, because we went through this discussion during the pre-hearing conference. So now that he said that, I'd object as to relevancy, as to where he's going with these questions. It's not relevant to the issues.
Mr. Reid,
We have pointed 89-3 for a while, the entire statute. This is a part of 89-3 that I've alleged is a violation. My knowledge of the statutes have grown over time. And we did allege violations in 89-3. I will say this, I was not aware that was going to be a very exclusive list. Of course, I'm pro se complainant. I put the issues there, but I wasn't aware that was an exclusive list. It's my understanding the board liberally interprets the pleadings of pro se complainants, and I did point to 89-3, and I did point to 89-3, and this is contained in it, and the protection of concerted activities for the mutual aid and protection of its members is a right guaranteed under 89-3.
I understand your position, Mr. Reid. What I'm saying, and it goes towards Mr. Alapa's objection. You need to tie this in to one of your claims, and if it's because that has to do with the relevancy. If you, and not for you to testify, so I don't really want you to respond to this, but how you're going to ask Ms. Eshelman to testify as to how, if you were blocked on Facebook, how that affected you. That's not a proper question for Ms. Eshelman. If that's something you will attempt to testify to, then so be it. But we're asking Ms. Eshelman questions right now. And so all I'm saying is I'm noting Mr. Alapa's objections. I'll let you proceed a little further with this, but not much unless you can tie it in.
Okay. I'll tie
You
it in.
understand?
Yes, I do.
Okay. Mr. Alapa?
And I understand you made a ruling, but I just want to make a statement for the record. And you know, the complainants and Mr. Reid has used his status as a pro se litigant as an excuse many times, and I commend them for what they're doing. I know it's not easy. However, the pretrial statement, the pretrial orders are very clear that the purpose of our pretrial statement is for the complainant to address the issues and to specify what the issue is. You cannot rely on the general applicability of a statute. The whole purpose of the pre-hearing statement is for the parties to understand what the claims are, for us to prepare, for us to provide exhibits. And then we go to the conference, we talk about it, we allow exhibits based on those issues. So the 89-3 reference is specifically from their own mouths, is based on not demanding negotiations or filing a prohibited practice complaint. So cannot rely on just a general law without giving us notice. It's a due process violation. But I just want to put that on the record. Thank you.
And that is noted, Mr. Alapa, and like I said, I'm going to give Mr. Reid, since he is a self-represented litigant, a little leeway, but I stress the word little leeway to tie this up. And if he can, then your objection will be sustained.
Understood. Thank you.
I just want to say I don't think I've asked for any special privileges.
Mr. Reid, you can proceed.
Okay. Did you read the email I sent you regarding that incident?
What incident?
The being blocked from the Maui chapter Facebook group.
I get between 100 and 500 emails a week. I do not recall a specific email from you. You may have emailed me. I am aware that you were blocked from the Facebook group for Maui.
Okay, that's it. Well, there's one more question. Are you aware of why I was blocked from the Facebook group on Maui?
Yes.
Okay. What is your understanding of why I was blocked?
So our social media platforms that are under the banner of an HSTA and run by HSTA leadership in the case of chapters with guidance and advice for best practices and legal means and things from our communication shop is such that when someone goes on our Facebook groups, which we own for our communication purposes, this was not your Facebook group. This was HSTA Maui's, which is a closed platform. So they vet all the people who are on there. I will tell you that at that time, I was not part of the Facebook group on Maui. You were actively on the Facebook group, encouraging people to drop their membership and send you money because you claimed that you had a lawsuit against us. We do not allow people to go on our communication mechanisms and tell people to drop their membership. And what you were putting out was false. You had never filed a lawsuit against us. So that is why you were blocked.
One question. Have I filed a prohibited practice complaint against the HSTA?
Yes, but not at the time that you were asking to do that. And it's not a lawsuit.
All right, switching gears. Have you been personally involved in the creation of the pleadings and the prior documents in this case?
Objection, relevancy, attorney-client privilege, work product privilege. She submitted declarations. If you want to talk about something she signed, that's fine, but this is out of bounds.
Okay. I'll
Yeah,
be
that's gonna be sustained.
okay. Not for sure yet.
I understand.
Are you aware that in the HSCA's pleadings, at least once, I think twice, the HSCA has requested that if you win the case, that we pay your legal, the union's legal fees?
If I can just ask for a reference on what pleading they're referencing so I can assure its accuracy.
I believe it was the late, because there's been a few, the latest or the last motion for summary judgment. I could be wrong, but
Well, I need more specificity. Then it's calls for speculation, lacks foundation, doesn't even know what pleading he's referring to.
And Mr. Reid, and I can give you the time if you wish. But it's only fair to Mr. Alapa and his client that you give a specific reference
okay,
to what you're referring to.
Oh. Could I, well, our questioning may go past lunch, so could I'll ask the question after lunch? Or a few?
Yeah, we can take a lunch break now. If you don't mind, if we can come back at 1.
That's fine.
Because I want to make sure
that's fine.
that Ms. Eshelman's testimony is that
Yeah,
okay?
just-
Mr. Alapa?
If I apologize, I have a meeting at 12 o'clock actually, which I was gonna be late to, but sounds like I can get there. Sounds like I can get there, but it was gonna last an hour.
Okay, why don't
Maybe.
if we say 1:15?
I'll do my best. I think I can do it.
No, and I understand if you're not here at 1:15, but if you are, then we can start early, if that's okay with Mr. Takei.
Sure.
Mr. Reid.
That's fine.
Okay, let's try to be back at 1:15 and we'll take our lunch break now. Thank you.
That's it. Oh,
I'll go up with you now.
yeah, sure.